Okay, we have some time for questions. We have two microphones, and we want to take some questions right away. Yes, right here in the center. Right there, yeah.
Alexander, you very persuasively made the case for us making the case for separating, and the two models that you gave us, that we make the case for following, seeing Obergefell in the history of the sexual revolution and substantive due process decisions by the court or other ways of expanding liberty and sexual liberties that many of us propose, contrasting that with that which is generally accepted by society, which most of us, probably all of us, accept in civil rights legislation. Gene, you brought up in your presentation that the Roberts Court, I believe it was maybe 5, 6 decisions, all of them but one, finding on the rights of for religiously motivated conduct. The one exception to that, of course, was Christian Legal Society. By my count, the only case that dealt with sexual orientation in the group that you mentioned. At the heart of that case is a distinction between behavior and conduct. That's also at the heart of what Alexander raised with respect to civil rights and the comparison between civil rights and abortion. One, on the one hand, orientation or attractions being seen in a characteristic. The other, sexual behavior, being conduct growing out of the sexual revolution. Right now we have a 5-4 majority that have said that sexual behavior and the conduct cannot be separated. How do we make the case, and making the cultural case for, I'm being a little bit brief when I say cannot be separated. I should say that a distinction, a discrimination based on the conduct would be equated with a discrimination based on the orientation. I'll probably be brief in my description of Christian Legal Society. But getting at this fundamental issue of distinctions between attraction and distinctions between behavior and conduct, how do we make the case in a religiously declining society for separating those two out, so that religious institutions and religious individuals can continue to make distinctions based on behavior that they oppose without offending or being accused of discriminating against orientation, which they can, consistent with their faith, respect.
Okay. What's it? You want to take it? Yeah, go ahead.
Mike, I think the short answer to your question is to do a lot more of what you did so effectively in the amicus brief that you filed in Obergefell, which was essentially I don't know how many of you saw that, but it was a collection of testimonials from a number of gay men who married women and are happily raising families together. Many of them have their stories on the Voices of Hope website, and I think that's, I think that's the best thing that we can do to continue to draw that distinction between attraction and conduct, is to be able to point to real-life examples of people who admit to having strong same-sex attraction but who have made a different choice than what the LGBT movement wants us to believe is the only acceptable choice.
Could I respond a little bit to that as well?
Sure.
That's going to be a hard project, right? I mean, that's going to be difficult, and we're going to need to do some of that. But I think even more importantly, we need to show that beliefs about sexuality are profoundly important to us and our lives, and to our own dignity and our own identities. And when we establish that, then other people, good people, have to respond. They have to say something. They have to react to that. This is profoundly important to me, your move. What is your move going to be? Are you going to suppress me? Are you going to force me to do something I don't want to do? Or are you going to respect me? And we need to find ways to articulate why it is that these things are so profoundly important to us, how they relate to our identities, to our dignity, to our individual lives. And when that happens, and when we find those words and those ways of being persuasive, American people are generally tolerant people. Americans don't like to force people to do things that that hurt, that go against who and what they are. And I think we'll find a great deal of empathy then in the American people for not only our beliefs, but for the institutions that allow those beliefs to flourish. So sometimes we may have to be drawn into very narrow arguments, like the desire conduct distinction. But I think very often we're going to have to do a lot more of explaining why particular things are important to us and why they're profoundly related to who and what we are and how we live our lives.
Thank you. We have a question over here, if you could be brief with your question.
Yeah, we reviewed Justice Kennedy's statements in Obergefell, stating that people could have good faith religious beliefs to justify their opposition to same-sex marriage. I've not read United States versus Windsor, but I thought that in that case, Justice Kennedy actually said only animus could explain someone who opposes same-sex marriage. Do I misunderstand Windsor? Is there a contradiction or not?
Gene?
I don't think there's a contradiction. Windsor did conclude that based on the legislative history of the Defense of Marriage Act, he felt like the only explanation for what Congress did there was animus. Now, I think he was wrong about that, but as we saw in Obergefell, that reasoning, in his view, did not carry over to the democratic process that had caused so many states to enact protections for traditional marriage.
Thank you. Let's see. We have a question right here. If you could be brief, thanks.
You mentioned the Smith case, and I reread that after Obergefell, and Justice Scalia mentioned in that case that when you combine the free exercise clause with some other constitutional provision, then you get back the heightened scrutiny. And I'm wondering what your thoughts are on using the Kennedy approach, that dignity and the other areas that he said are now protected by the substantive due process clause cannot be used in combination with the free exercise clause to argue in favor of the religious liberty that we were talking about yesterday, going to the very core of our identity and that type of a thing. I'm wondering what your thoughts are about that.
Yeah, that's a creative suggestion. I don't know that we'd get Justice Scalia to buy that, but it's a creative suggestion that deserves some exploration in a particular case where it might be useful.
It's not clear the Supreme Court was really serious about this hybrid rights notion. They may have been or they may not have been, but the tool is still in there. And so as outrages arise, as bad facts, or in our case perhaps good facts, arise, you may be able to combine and mix and match some of these theories in order to get around some of the roadblocks that Smith creates. Kennedy, of course, got around a ton of roadblocks to get to where he got in the Obergefell decision. I mean, he just completely swept away entire lines of precedent on substantive due process to go where he eventually went. And that can occur in other contexts as well, in the religious liberty context, if you get the right case.
Let's see. Let's go with Don here, and Dino. Don, go ahead.
Thanks. Just I'd like to have you comment on a quote from Elder Dallin H. Oaks on the occasion of his appointment to the Utah Supreme Court. He was asked his opinions about the Reynolds decision of decades before, but it was relevant to him because two of his ancestors had spent considerable time in federal prisons as a result of that case. Now he was coming to the Utah Supreme Court, and a reporter from the Deseret News asked him his views now, if he would reflect on that case and its relationship to religious freedom. This is a quote that we don't hear very often, and I, for that reason, would like your comments on it. I am of two minds on whether the Reynolds case, on the Reynolds case. On the one hand, it was a terribly prejudiced ruling. On the other hand, it correctly put limits on how far religious practice could be permitted to go. And there have to be some limits to religious practice, even though it's protected by the Constitution. The Reynolds case was a first cut at putting limits on religious freedom, and those limits had to be placed. So I appreciate your reflections on that, whether there's any relevance today.
Raman, do you want to say anything?
Oh, yeah. So I think, you know, when we have a contest between individuals in the state, I'm going to step up for religious freedom as much as I possibly can, right? With consideration for access. But the one place where I think we should not want to do that is in the debate about giving deference to religious norms in the family, because in my view, that's a zero-sum game. So if you say, for example, that you would give deference to certain Islamic notions of how property should be held or split in the family, that actually means that these women lose, right? So in one of the 7 schools of Islam, for example, you pay alimony for 3 months. I don't know if any of you all have ever paid alimony, but every person I've ever met that paid alimony is like, woo, 3 months and I'm out? That's for me, right? Without respect to whether these women would be in fact cared for by their fathers or their sons in that system. And it turns out that many of these women in fact are left adrift in that system because their religious norms for some reason just flee in the face of a social safety net, right? And these people get dropped on the social safety net. Likewise with property, likewise with custody, right? So women would lose custody of their adolescent children in favor of the father without respect to best interest of the child. So there are times when we should not tolerate religious outcomes or claims for religious freedom when they are going to have when they're going to represent sharp breaks from what the civil state has said we do to protect dependents.
Thank you. We have time for one more question. Dino?
Hello.
I think it's working.
My question is a follow-up, actually, kind of to that. In your argument against separating civil marriages from religious marriages, you speak about exit rights and divorce. But if you're speaking to a community of faith where most of us don't get married and we want to consider what we're going to get when we get divorced, what is your argument?
Well, so my argument, you know, I'm not sure. I told you it was a start, and I only had 10 days, and I don't have a very good answer to that. I think my argument would be something like, religious people share my faith in marriage, and we want marriage to pay the dividends that it pays, but we don't actually know why it does that. And I don't doubt that most religious people that have experience of marriage believe in fidelity, believe in permanence, believe in selflessness, believe all of those things. But sort of surrounding those norms are legal rules that put payment to those beliefs. In other words, think about the exit costs in some states. If you have children together, it would be a year in Virginia, right? If you don't have children, it would be 6 months. That's the state actually saying that we should be slower to divorce when children are implicated. And that actually pays dividends even to the religious people who find themselves sometimes having to divorce. And I don't mean this to be, by the way, a tirade against divorce. There are times when divorce is necessary in cases of domestic violence or adultery or other things that are not considered deep breaches in the marriage. But I think those exit rules reinforce a religious norm, and my fear is if you unbundle those and you have exit rules over here and religious norms over here, that the religious marriages are impoverished, potentially. I'm not confident of that, but I'm dead confident that the civil marriages will be made worse from being divorced by religious norms. In effect, I think civil marriages, what little bit is left good in them, has been free riding on religious norms. They have been buoyed by religious norms. And I'm afraid if the religious marriage and religious people withdraw from the world, it will be to the worse for the marriage culture. So that's my basic premise, but it's more on this side than on this side.
And of course, there's a great irony in that, because many of the civil marriage people have not appreciated the extremely important value of the religious side of this joint civil religious compact that has existed and sustained marriage throughout history. They've really disregarded that and thought, well, you know, what's the big deal? You want to do your Catholic marriage, go to your Catholic marriage. It's not really an issue for us. When in fact there has been this, again to use that terrible word, symbiotic relationship between the civil and the religious side that has bolstered marriage. And one of the big questions is what's going to happen to the marriage culture in the aftermath of the Obergefell decision. Are religious people going to be somehow repelled by this new civil marriage institution that includes same-sex unions, which they cannot agree to? And what's that going to cause them to think about and to feel toward the institution of marriage itself? And questions do arise about how then best to preserve the sanctity of marriage as an institution that guides men and women together for the benefit of their children.
Gene, you have the last word.
Well, thank you. I just wanted to say a big amen to both Robin's and Alexander's comments urging us not to adopt a position where we say, well, the state should just get out of marriage. I mean, the reality is that the state's involvement in marriage, despite the challenges that Obergefell poses, the state's involvement in marriage is very important to a large portion of the population, which, as we saw yesterday, is, they're probably only about half the people in the country who have any strong attachment to their faith, and so, and some number of those people have some, are going to listen to what the government tells them, even though they won't listen to what any faith tells them. And so people who are not strongly attached to religion need, I think, the state to continue to tell them, look, if you're thinking about having kids or you're thinking about doing anything that might result in having kids, you need to be married. And the more voices we have, the more credible voices we have in our society who are continuing to send that message, especially to young heterosexual couples, the better off we're going to be as a society. And to the extent that we withdraw any of those voices that are sending that message, we're going to be much worse off, and our children are going to be worse off.
And our religious liberty will be worse off.
Yes.
Because
Exactly.
the viability of religious marriage, of those who understand marriage as a religious institution and live it, is going to help to determine society's and the culture's response to religious liberty claims based upon those beliefs and based upon that conduct. If society views us as valuable and precious and doing great things, then it'll be far more likely to respect it.
Well, thank you very much. I think you can all join with me in expressing our deep appreciation for this outstanding panel.